Welcome to another episode of Harbor Rock Wealth Management's podcast series, Life, Health, and Wealth, where we discuss financially driven topics and how they relate to our financial lifestyle. Today we have a special guest, John Stifter from Stifter Law Corp.
Welcome, John.
Good morning, guys.
Thanks for being here.
Thanks for having me.
He's Ruben Smith. I'm Jimmy Luster. And as promised, I always offer a stat of the day, and it is a sports stat of the day. This day in sports history, Larry Bird retired after 13 years with the Boston Celtics. So 1992, and I think that was that also the time with the Dream Team?
It was.
Right around that time?
The 92 Olympics, yeah.
So he retired at the top of his game, went and won a gold medal, and bronzed the shoes. I think that was a good outro for Larry Bird, for sure. And also, I have a quote of the day, and it is a sports legend, Yogi Berra. And anyone that knows yogiisms, they're quite funny. And I have it written down. It's, you can see a lot by observing. I think that's actually pretty funny. And our topic today is estate planning, which includes trusts and other various aspects of estate planning. And going back to that quote, you can see a lot by observing. In my banking years, I knew that I saw a lot of trusts come by my desk and a lot of legal documents. And I did observe quite a bit, and I saw lots of different things in there. So we're excited to have John here to provide some color and its insights to give us a little direction and deeper dive on estate planning today. But before we do that, John, you've had lots of different looks. I've known you for a long time. And I've seen you in anything from khakis and polos to a short, tight haircut, clean shaven. But I think with your look now, you are definitely the coolest attorney that I know. It's pretty cool. But you're not originally from San Clemente. I think you're from Ohio that you shared with us. Can you share a little bit about your personal and professional background?
Yeah, I grew up in Cleveland, Ohio. Great place to be from, a little bit cold on the weather for me. So at some point through the years, decided the place I wanted to settle was here in Southern California. Been here for my entire career. Went to Denison University back in Ohio, econ major. A lot of lawyers go to college. They don't necessarily pick up a subject that might be helpful in estate planning.
Yeah.
But having a good handle on numbers can be helpful in what I do. Went to law school at Thomas Cooley in Michigan. It's a very good school, right in the state capital. Law review, cum laude, top 10%, all that good stuff. Also went on after my JD to Cambridge University in England, got an LLM. That was in international law. People sometimes say, what in the world does international law have to do with what you do today? But it sometimes does. I have clients that have places down in Cabo. I have clients who have places in Costa Rica and other places. And so that background sometimes is helpful with certain people with extra tricky estate planning issues. But eventually, I certainly decided that Southern California was the place for me. Took the plane from England to Los Angeles and never went back.
Wow.
I was in practice originally in downtown Los Angeles for a number of years. Big firm sort of experience, and eventually, though, decided to start my own practice here in San Clemente. I've been in San Clemente in practice here since 2003, and love it. Love being here. Love the practice. Love the lifestyle. Good folks here in Southern California that I'm lucky to work with.
Well, we share a lot of clients, and we've worked together quite a bit over the years. And you've definitely cemented yourself as an authority in the legal community and a local legend in San Clemente. Let's be honest. But so our topic, estate planning today, we come across this a lot, Ruben, in our financial planning exercises. I know one of the things we touch on every time when we're having a consultation is the idea of, do you have a trust? And some other questions lead from there.
Yeah, no, absolutely. It's part of the data gathering session, right? Getting to know clients and peeling back the onion a little bit and seeing where they're at financially. Also, making sure that their assets are what we think titled appropriately. Typically, if they do have a trust and assets are held in trust correctly, or what we think is correctly, the next question would be, well, when's the last time you updated this? A lot of times clients don't necessarily. They kind of put their trust on their estate plan on the back burner, unfortunately, and it's not something I think necessarily you need to look at on a quarterly basis. And correct me if I'm wrong, but perhaps every life-changing event, whether it's an addition to the family or maybe you had a loss in the family, or you sold a property, business. So what I would like to hear from you, John, is really let's take a kind of a broad view on estate planning. Let's do an estate planning 101, if you will, and walk us through what does that exercise look like for a client of yours?
Well, let's talk trust for a moment.
Okay.
So,
Sure.
what is a trust? A trust is really made up of three people. You always, in every trust, have a settlor. That's the person who calls up the attorney or otherwise sets up the trust. Voila, you are now a settlor. Because attorneys like to make things complicated and confusing, there's another term that's used interchangeably and is synonymous with, and that's trustor. And then let's really make it complicated. There's even a third term, which is grantor. And so those three terms, settlor, trustor, grantor, all mean the same thing. This is the person who set up the trust. It creates a lot of confusion for people because the second person under any trust is called a trustee. And so I'll have people say, gee whiz, John, trustor, trustee, these things sound really similar. What the heck is the difference? I like to say that if you think of the settlor, the trustor, and the grantor as being the creator, that will help you remember that's what that position is. And that will never, ever, ever change. The trustee, which does not rhyme, it's got to be something different. And it is. The trustee is like the president of the company. The trustee is the person that has the power to sign at the bank, the person who's got the power to sign on the title of the house, and otherwise control the assets. And then the third person under any trust is called the beneficiary. And the beneficiary is the person who gets the benefits of whatever's in there. Now, that settlor that creates it, it's never going to change. It could be the Getty Trust. These are the people who set it up 100 years from now. In theory, it might still be doing something. But the trustee, that changes. Initially, that's typically the husband and wife if it's a couple, or a single person if an individual. But if someone gets themselves in a car accident, maybe they haven't passed away, but something happened, life event, they're not able to take care of business like they normally do, they get to name someone to take over, to take that next position. And that's a successor trustee. And I like to say the reason we call a trust is because you get to name who you trust to do the right thing in a bad situation. That's probably the most important decision that anybody makes when they're doing a trust, is who is the right person for that position. You can have a second backup to that person. Sometimes you'll have one trustee by themselves. Sometimes you'll have co-trustees. Certainly when it's husband and wife, that's co-trustees. Sometimes you've got multiple adult children and they're all responsible and get along well. Sometimes it can help save a burden of putting all the work on one kid's plate to have multiple, but there's always a risk of fighting. So you got to be careful about that stuff. It's really driven by the personalities and the family. And so you really need to spend time understanding the family dynamics and who works well together and what doesn't work.
Yeah.
Beneficiary is, the couple who set it up while they're alive. If one of them passes, it's presumably the other. If they both pass, sorry to tell everybody that's listening now, but I still have not figured out how to let people take it with them when they go.
Sure.
Much requested, still working on it.
Yeah.
Get back to me later and I'll see if I've got a solution. But
Sure.
for now, people typically name their kids or some combination of family that are to be taken care of if they pass. The trustees are doing the work of distributing the money and assets under the terms that are outlined in that trust. Now, when you do a trust, you also should do a will. But the type of will you do when it's a trust-based estate plan is commonly referred to as a pour-over will. And that's because it's designed to pour over everything that's in your personal name to your trust. Trusts control things that are titled in the name of the trust. Wills control things that are in your personal name when the music's over. So the two things do similar things in the sense that they both control money, and the will is controlled by an executor. The trust is controlled by a trustee. Those jobs are very similar, but they're different in the sense that they're controlling different pots of money. Typically, that poor is going to say, you know, if I goofed and I've got things in my personal name, please get it in the trust so it passes according to the wishes there. Wills in California presently may move a combined sum of $184,500. So if you've got 2 cars and a bank account that didn't get into the trust and they total up to $200,000 in value, the law in California is going to say, we're going to go see the judge. That process is called probate. Most people don't want to, you don't want to end up in probate. Why do you not want to end up in probate? You don't want to end up in probate because it's very expensive, for one thing. There's a specific statute in California that outlines it. It's kind of like a percentage like a realtor would get or something like that based on the size of the estate with a graduated scale, the larger the estate. So the amount that's paid is set by statute. And it's going to be the same whether you're in Southern California or San Francisco or you know, wherever in the state. But it's not unusual for people to throw around numbers of it maybe being as much as about, this might sound a little extreme, but it's not crazy, 5% of the estate. One of the reasons it can end up being in that range is the fees are not based on the net equity. The fees for probate are based on the gross estate value.
Oh, wow.
So if you have a $1 million house with an $800,000 mortgage on it, the fees aren't based on $200,000 in equity. They're based on $1 million value, kind of like a realtor when you sell a house.
Interesting. So if you have a $1 million, let's say you have $1 million estate, but only $200,000 is subject to probate. The fee is based off of the $1 million, not the $200,000 that it's subject to. Is that what you're saying?
Well, let's take it another way. Let's suppose we've got a $1 million house with a $900,000 mortgage. We have $100,000 in equity. That is going to be a probate matter because we're over the 184.5 in gross value.
Wow.
So, yeah, we'd be in probate. But yeah, the fees are based on the gross, not on the net. And that's something that's very important because taxes don't work that way, but probate fees do. So what are probate fees? I mean, they're the fees paid to the attorney. They're lots of miscellaneous costs. You have to pay to run ads in the paper saying, you know, hey, guess what? So-and-so passed away and they are going to have a little party down at the courthouse on such and such a date. And if you think they owe you some money, come on down. We're going to have a real good time.
Oh, my gosh. Yeah.
Good way to put it. Okay.
So,
have a little party at the courthouse.
You know, which typically, you know, probate's a lawsuit. 9 months, a year and a half pre-COVID would be typical at this point in Orange County and a lot of other counties. You know, it can be much longer than that. The courts are backed up. There's a lot of, you know, overload on the system really going on.
So
if
you were sitting with me and I'm trying to settle an estate that's subject to probate, would you say expect a couple of years at a minimum? Or
I would say, I mean, if you were the person petitioning, you would probably be, you know, put in a position of authority as the executor within 3 to 4 months ish. There's requirements that we have to wait a certain amount of time for the ads to run in the paper before we can even have our court hearing. Depends on how backed up the court is to get that first hearing. Depends on if there are objections. But you're in a lawsuit.
right.
You know, but yes, it would be at least a year, perhaps 2 years, somewhere in that range. It's going to depend on the complexity of the state too, and other factors, and whether people come in and fight. You know, but it's a lawsuit. People spend their whole lives trying to stay out of lawsuits. The last thing anybody wants to do is have their last act on earth to be to throw their loved ones into a lawsuit as the parting gift and memory.
Right.
That's why trusts are so popular. Trusts do not go through probate if done correctly, but it's critical that we don't just write a fancy trust which has got terrific language in it, but once you have that trust document signed and you've sat there at the desk of your lawyer or wherever you are and signed it, it's just like a new bank account that maybe had the initial $100 deposit in it and says, here's who can sign on this account. If we don't get any money in there, it controls nothing. A trust is the same way, except we don't have a teller that's maintaining a ledger of what's in the account. So it's on you to make sure you got your stuff in there.
That's right.
And that process is called funding. Okay. That's the term in the practice, is to fund your trust. you deal with it every day. You see people come in with trusts, and maybe they have their accounts in, maybe they don't, maybe their beneficiary designations are messed up and don't coordinate correctly. And so just having a trust is not enough. That's like half of the battle. You have to make sure your things are correctly in there. And we all know that we don't necessarily handle all assets the same way. We have qualified, non-qualified accounts. We have different issues that come across on those things.
Real estate, business.
Real estate, yeah. Do we have an LLC for a rental house, and how are we going to get it in there without increasing the property taxes? That can be done. It should be done. We want to think about step up and basis issues. All right, but let's talk a little more about where we are in the 101 aspects.
Okay, sure.
So we've got a trust, we got a will. The next thing that you should be doing in your essential items of an estate plan these days, you should have a financial power of attorney. And the person with power under that is called your agent. Now, financial power of attorney is going to let those people you trust sign anything that you can sign for the most part. That is in your personal name. So this is not for things that are in the trust. If we got it in the trust handles it. But there are some things we cannot get into the trust, as we were just sort of alluding to. Maybe a qualified account that we cannot transfer into the trust. Tax returns that continue to have to be handled. Maybe a claim against your insurance company to get medical benefits. That's a financial claim. Maybe there's Medicare, Medicaid, Social Security, other things that might need to be dealt with. Maybe an automobile that somebody didn't want to spend a whole day down at the DMV getting into the trust after they did it. That still needs to be handled in a certain situation. So that financial power of attorney is going to usually have the same list of trusted people. The will's usually going to have the same list of trusted people, your executors and the trust and the trustee sort of mirror each other so the left hand knows what the right hand is doing.
It's common to have the same person being the executor, the successor trustee, and financial power of attorney.
It is common. And very, very rare occasion I have encountered situations where there might be a reason to have it broken up, but usually it seems to make sense that if you trust these people, it makes sense that left hand knows what the right hand is doing. So what we've got is we've got the financial power of attorney handling things that are in your personal name for one reason or another, but that document, it only is valid while you are alive. If you die, it dies with you. I always cringe when I hear somebody talking about how their mom or dad or husband or wife passed. Don't worry, I have power of attorney. I'm running around town, using it.
Yeah.
Oh, no.
Yeah.
Yes.
It is not to be used after the person passes for things in your personal name. Instead, the will is supposed to take over at that point. And if we're under $184,500, we don't have to go see the judge. If we're over, we're going to have to go see a judge. We'll get to handle it, but hopefully we're under 184.5. Mostly, we got the house in the trust, we got the bigger accounts in the trust. Great. Everything is in the trust controls. So really the trust is plan A. The will and the financial power of attorney are plan B. They're a backup plan.
So would another way to look at the pour over will, is that kind of a catch-all? I hate to use that word, but and what would be, is that where someone can specifically say, let's say a family heirloom,
or a trinket, or the grandfather clock, or
or is that just a broad basket, I guess, to collect anything that wasn't titled correctly?
Great question. I get asked that one a lot, and I see a lot of wills and trusts. I've probably seen thousands that come in from all kinds of lawyers from all over the place, and you see different approaches. But personally and professionally, no, I do not think the will should be used to be a catch-all for your personal effects, because that has some value to it and is now potentially increasing your risk of exceeding $184,500.
Subject to probate.
So some people have expensive paintings and artwork and jewelry,
car,
and you're just needlessly increasing the risk of exceeding that number.
Interesting.
The trust is a much better place to handle those types of things. And thankfully, there is not a Department of Jewelry in California or a Department of Fine Art yet. So we don't have to go down to the DMV type institution. All we've got to do is have it clearly notated on what's commonly referred to as a Schedule A or to your trust, which are the assets that are going in the trust. So we don't have to change a title somewhere or update a bank account. We just have to list that they're in there. And then, people change their minds sometimes over time, about who they want their watch to go to or this heirloom, and they want to noodle on it and think about it. And, with a trust, if you have it in there, there's a clause that I can include, and a lot of times I do if somebody wants it, where they can change from time to time who might receive those kind of sentimental, personal effects without having to go back in and incur the expense of sitting down with an attorney, and they can just update from time to time. Trusts will allow them to do that. Wills will not. So a will has very, very specific requirements. If it's typed up, then we have to have 2 witnesses. They have to be over 18 years old. They can't have any connection to how they might inherit. It can't be a kid of yours or a brother or whatever.
I've always heard this thing, you can write a will on a napkin and it's fine,
There
Is that true?
can be, you can in California do what's called a holographic will, which requires that it be entirely as to the material portions in your handwriting. It has to specify that you mean it to be your will. It has to be dated and signed. And really, what you're getting into is a very formalistic document. Trust me, people do not want to rely on the technicalities of what's required for a holographic will. Just leads to undoubtedly potential risk of sending us into court later on. Much better
when
handled.
Times like everyone's grieving and like this whole process. It just totally seems like you would want this to be as cut and dry as possible, so you can worry about what's important is grieving your family member or
That's right.
handling affairs. The effects and affairs that need to be taken care of without wondering if your document's going to hold water when you have to go to court now and add all this stress. Sounds awful.
And really as a lawyer, that's why I like what I do. Because as a lawyer, there are so many things that you are hired to help with that there are no good solutions and it's going to be a mess and you're in court or, you've got all these just bad results because you're in court. With advanced planning and done correctly in a trust, it's really one of those things as a lawyer I can do where I can save people money a lot of times on capital gains potentially because they aren't holding assets correctly or avoid a property tax reassessment that still gets them where they want to be, but through better financial terms. And when life happens, the last thing people should be worrying about is making sure that those things have been handled. So I've had many clients come back after some sort of life event and thank me because they were at peace at least with the legal stuff, as they say. And that does allow them to just be present in that moment and focused on where they should be. And that's, that's a good feeling when you have that happen over and over.
Well, it's almost like an investment in your family's well-being. You make lots of investments in your life. The trust isn't for you, the one that you're making, the people. It's for your heirs, your family, so they can do just that. You are investing in your family's well-being. I have personal experience with that. A lot of our clients do as well. And that just seems like something so important to set up ahead of time and actually take that and make that investment to make sure it goes as smooth as possible because it can be really tough.
That's right. And while we're wrapping up the 101 aspect, there's one more document that people should definitely do, and it's also called a power of attorney, but this one's for health care. Sometimes it goes by other names. On the East Coast, I'm pretty sure that they're referred to as living wills, which really confuses people because they hear living will and living trust. But here in California, it's a healthcare directive or a power of attorney for medical decisions. And, under that document, you also have someone called an agent, just like with the financial power of attorney. But the agent under your healthcare directive has power over something more important than your money. They have power over pulling the plug on you. So think wisely.
Right, right. And so this person would have access to your medical records to be able to make those important medical decisions or healthcare decisions for you.
Well, it's interesting because the medical power of attorney or healthcare directive can be broken into 3 separate documents. So sometimes I'll see attorneys who take a drafting style where they will break it up into multiple medical related documents. Okay. Personally, I prefer to have one cohesive, everything is here, but conceptually we are covering a couple different issues in those documents. One is the power of attorney. That's the person who has the power to sign papers at the hospital or with whatever medical provider to authorize this procedure versus that procedure that is deemed to be most warranted if you are not in a position to be signing those papers. That's the power of attorney. Separate from that is a HIPAA waiver, and that's the federal law that went into effect in the early 2000s, mid 2000s, somewhere around there. That now is pretty commonplace, but it's important to have a HIPAA waiver. So obviously your agent needs to have a HIPAA waiver. They can't make good medical decisions for you if they can't ask the doctor what's going on.
Right.
But so yes, your agent should be on the HIPAA waiver, but sometimes your HIPAA waiver will be a larger group because you might have your 2 people that you feel are the right people to potentially make decisions. Maybe they'll be joint so that they can trade off. Hey, I'm on for 12 hours. You go home and get some sleep and stay here with mom or dad or whatever, and then you come back in and swap me out. But the HIPAA waiver is the list of people that are allowed to hear what's going on. If the doctor comes out with an update and isn't going to be worried that having these people present somehow might violate healthcare disclosure laws, and who's allowed to stay here and hear the update, who's allowed to call the hospital if you got relatives that live far away, that's on the allowed to know what's going on list. So the HIPAA list can be broader for sure.
Okay.
And although it sounds kind of silly in a way, the healthcare directive is where people can make decisions about if they want to be buried or cremated and these kinds of things. Neither sounds like a good choice to me. I'm still looking for a better one, but sometimes putting that in there brings peace of mind to kids, because they just want to do whatever mom or dad want them to do.
Yep.
And sometimes if it's in black and white, there's no guessing. Because sometimes there've been conversations. Well, I remember when I had this conversation with Dad. Well, yeah, how old were you then? You were that was back when you were 20. Well, that was 20 years ago, 30 years ago. Dad's changed his mind.
You brought up a good point about this black and white. Everything when you go through the estate planning exercise and you have everything updated or everything's current, your trust, how your beneficiaries or your assets are going to be distributed. That really removes a lot of confrontation. Well, I think that's the hope, that removes a lot of confrontation upon settling an estate. We've all been involved with settling estates, and we've seen some pretty nasty situations. Unfortunately, I'm convinced that money is the root of all evil. And people just completely change.
Well, it can surely bring out the worst in people.
Yeah,
and even unintentionally. It's emotional. It's an emotional time. Sometimes that gets the best of people, and it is nice to have something almost like an entity to rely on that's outside of that circle. It's like, look, this is what's in the document. Yeah. We're following the document. The instructions have been settled. It's nobody's opinion. I'm not the oldest, so I'm going to take over, or Dad loved me the most, or it just eliminates all that. But you still have issues and friction and static. That shows how important that document is. Yeah. I mean, that's incredible.
Yeah, I'm not a psychologist. Maybe it would have been a good skill set to have.
Well, we all play one sometimes. There's an element to that.
But there is an element that when the patriarch and the matriarch pass on, that there can be the sibling, rivalries that have gone on. There's, the frustration that when I was little, I got in trouble for something and it was really you. And, you never told them it was you. And
Sure.
there's all kinds of stuff that, you add that with money and, who knew mom and dad best, as you say,
Yeah.
James.
Yeah.
Favorites, playing favorites, and all
So,
Yeah,
so
get out
mom
the
and
tent.
dad,
Circus is here. Yeah, it's
mom
tough.
and dad do such a good thing for their family. And sometimes it's not just for the kids either, though. It can be for just the spouse, and sometimes trusts are, despite the main goal, which is for the kids, it can also be for yourself, because if you are banged up and there's going to be a period of time, you're spelling out who should be making sure the medical bills are getting paid, and there's not a fight over controlling the assets while you're alive, which are conservatorships a lot of times. And the trust avoids that, which is a very expensive, very awful process that you keep your family out of, because you have set in place a plan for all instances during your life and after you've passed. So it's in black and white.
Well, I kind of wanted to ask you that. So, Ruben has a family, children. My mom and dad got their trust done. Children, obviously. Why would someone like me need a trust? It's me and my wife. We have assets, but it's not overly complex.
You got a dog.
We have a little doggy.
Who's going to take care of the pup?
That's right. But fairly simple in those aspects. Not a ton of moving parts, but we do have that property. Why would someone like me and my wife need a trust?
Great question. And I think the reasons people need trust and estate planning are going to vary based on where you are in life. Sometimes I'm not saying you've got a smaller estate, James. I'm not suggesting that, but
a man is not measured by the size of his estate.
but sometimes the smaller estates almost require the planning more than the large estates. If you're a billionaire, you got $100 billion in your bank account, and you don't have it all planned out, and you pass away, and they end up in court and they drop $1 billion in legal fees to figure it out, there's still $99 billion to go around. I think the kids are going to be okay financially, at least, right? But if you've got a $1 million estate or a $500,000 estate, and we have to spend $50,000 or $100,000 in legal fees to go into court, that hurts. That's real money that didn't need to be spent or lost, and could have been used for much better things. So sometimes on the smaller estates, it can be even more important, I think. And I'm going to give a quick example, probably the smallest estate I can think of. I won't give names, and I won't get real specific, but a lady came to see me on a Friday. She had a $200,000 estate, and she was very nervous because she had been told her husband was fatally, terminally ill. He's at the hospital and would not live more than a few more days, and that he had forbidden her from ever speaking to a lawyer about estate planning because he was confident he had taken care of it and she had nothing to worry about, and that would be a waste of money. But she decided to sit down with me anyways, and it's a good thing that she did, because what the husband had done, which is logical, is he had put his wife's name on some very old stock that he had gotten from some job or something in like the 70s. And this stock had appreciated substantially. So if he were to die, he was correct that she would be the owner. She would not need to go to court. But the question I had for her was, ma'am, will you need to sell this stock to live on? And she looked at me incredulously like, of course I will. This is all I have. I said, that's what I assumed. But what the problem is that when your husband passes, because he's put your name on it, there will be no step up in basis. And by my calculations, you're going to have about $70,000 in tax that you're going to have to pay to sell that stock, give or take. Would you prefer to not pay that tax?
Yeah.
Would that
right.
$70,000 make a difference in your life, ma'am?
Right.
Right.
Absolutely. And I said, well, what I'm about to tell you may sound very strange, but we need to get your husband's name back on this account and immediately.
Right.
So this was some old school stock. There's some guy in New York. It's like, 1 o'clock on a Friday we call. Believe it or not, he's there at 4 o'clock.
Wow.
I explain I need the whatever forms to update the account. He emails them. I fill them out. I get her husband added back on. I notarize the document. I put it in FedEx to New York because it's got to be old school. I say, she walks out the door. It's all done. I say, if anything happens, don't tell anybody your husband passed. Sunday, she called me. My husband passed. I said, well, I'm sorry, but in the meantime, don't say anything. They got the papers on Monday, got updated, and she saved a lot of tax.
Wow.
Yep.
So
That's incredible.
that's and that's a small estate.
That's
so
impactful.
why does somebody with a small estate need the planning? Because every penny counts.
Sure.
Well, I couldn't agree with you more. Right? There's clients. We have clients of all asset sizes, but I feel like some of the clients that we have maybe that are behind the curve as far as planning, they need more dedicated planning and more white glove treatment in a lot of cases because we don't have a lot of room for error. So I couldn't agree more.
Yeah.
That everyone is ripe for a plan. in my
Yeah,
opinion.
and on the larger estates, if you've got 20 million, 30 million, 40 million, okay, we're not in billionaire class, so maybe we still need to be careful about our money.
Yeah.
Sure.
But when you got a $20 million estate or a $40 million estate, there's a lot of tax you can just step right into that is avoidable in enormous numbers. But you got to do the planning, and so it's a lot different layers of planning you do on the larger estate. There's going to be more elements to that estate plan than the 101 aspects. We may get into things called fractionalization with LLCs, maybe FLPs. There's a lot of there may be a limited amount of gifting done during life to help with that fractionalization. There's a variety of things that need to be looked at. We certainly want to make sure we're getting our step up in basis.
Well, I think we should have him back in to talk about whether it's estate planning updates or maybe some of these nuance or more specific niches within estate planning.
Yeah. It's also a great time to move into estate tax thresholds. We can always circle back around anything about probate or the estate planning 101, specifically trusts, medical directives, things of that nature. But now you're touching a little bit on some of these tax pitfalls and potentials and traps that you might be walking into and how important it is to know you don't know what you don't know, right?
That's right.
And so be educated and specifically speak to a legal representative about your specific situation because these things change. And I know they don't change overnight, but we're aware of some things coming our way in the future, but we don't know what's going to happen 10, 15, 20 years from now. And to make sure that your trust is always updated and you're continuing that conversation. Can you provide us a little information on anything you know about estate tax thresholds and any changes that are coming? Or?
Sure. Let me put it in a little more contextual sense, though. I just feel like you can't just grab the current and without looking at a little history on this.
Sure.
So the estate tax, also known as the death tax, the estate and gift tax, they're unified. So that means if you give away money during life or you do it at death, which is when most people do their biggest gifting, there's a special tax. And there's so many taxes, right? We've got income tax, capital gains tax, sales tax, real property tax, gas tax. But this is a very special tax. This is triggered from different reasons than all those others just made everybody nauseous with. This is a tax, when we talk about the estate tax, that is due when you die. It's due within 9 months of your death. And so historically in the U.S., there's been an estate tax for many, many years. It was put in place for families like, the Rockefellers and trying to avoid having these massive estates just continue. But it these days hits more common people, if you will. We're not just the Rockefellers that have to worry about this. We've got to go back to, let's say, 2001. If we go back to 2001, in that year, you were allowed to leave $675,000 either during life or at death. And it was a graduated tax scale that went up to, I think, 55%, fluctuated a bit. That number had been in that range for years. I mean, you go back to the 90s, even the 80s, and it would change $1,000 or $2,000 in a year for inflation and small changes. But along came Bush. And Bush said, gee, people are losing their family farms because when mom and dad die, this family farm on paper is worth this enormous amount of money. And so these farmers literally couldn't pay the bill, and family farms are being lost. This is not America. This is stuff that's been taxed already anyway.
Right.
So Bush increased it. And in 2002, the number went up to $1 million. So we had a $325,000 increase, which was a big increase to happen in a year. And over a period of years, as the Bush tax rules rolled out, in 2004, that number went to $1.5 million you were allowed to have when you died. In 2006, it went to $2 million. In 2009, it went to $3.5 million. Everybody's saying, John, we like this. Keep going. All right. 2010, infinity. You were able to die in 2010, be a billionaire, and pay no estate taxes in that year.
Wow.
But under the Bush rules in 2011, the free ride ended, and the number went back to 1 million. So this exemption that got bigger and bigger and bigger through those years was going to come crashing down to the 2002 rules in 2011, 1 million. Then along came Obama. Obama looked at this and said, $1 million, that's not sensible. That's too small.
Yep.
A lot of fighting in D.C. that year. Not that that's something that ever happened.
Yeah.
Shock.
But ultimately Congress and Obama came together and agreed to bump it to 5 million for 11 and 12, 2011, 2012, and an option on 10, but we won't get into that technical level. But it was set to go back to 1 million again in 2013. Then at the last minute, they got their act together in D.C. and said, all right, we're just joking. We're not going to actually make people start paying tax on $1 million estates again. And it got set to $5 million, this time, quote, permanently. We'll see. Mm-hmm. Along came Trump. Trump campaigned, among other things, that he was going to do away with this tax. Personally, I thought that was why he ran, save a few $100 million, maybe billion for his kids.
Sure.
It makes sense. It's a good business move for sure. But he did not get rid of it in the end. What he did was he doubled Obama's numbers. So the 5 million became 10 million. And right now I'm not using the adjusted for inflation numbers. I'm using the base numbers.
Okay.
These numbers are a little higher because of inflation through the years. But I'm using the base numbers. In theory, we could have deflation. They could go back down. But let's hope that doesn't happen in America. It won't. It won't, folks. But right now, we're still under the Trump rules. The sunset you're talking about, much like the Bush policy, okay? Trump did it so it was in place for 8 years. That would be the same road that Bush had taken. It was an 8-year patch. So under the Trump rules, in 2025, we go back to the Obama numbers, which are 5 million. Whether that's going to really happen or not happen is going to depend on a pay grade above me.
Gotcha.
That's going to have to do with who's in Congress. That's going to have to do with who's the president. It's going to have to do with how the economy's doing, how much red ink we've got. Are we going to pay down the deficit? Are we going to tax people more? There's so much behind that. But what I can say is that it's pretty clear that in politics, they like to play with this.
Right.
That number has changed, basically a half a dozen times at least in just a few years, period. So expect more changes.
So
that's
in other
what people
words,
should expect.
From a planning standpoint, someone shouldn't not plan because they're under a certain threshold. Maybe they wouldn't be subject to estate taxes today, but it sounds like things are expected to change just because that's the norm with estate taxes.
Yeah, and so let's take that one. I like that. And this goes to how, do we need to do estate planning at a certain size or not? But let's suppose we got someone who's close call. Maybe they're at $6 million estate. And obviously with estate planning, what we can do is various trusts and other approaches to preserve the first spouse's tax exemption so that later on the kids can inherit more. So if we do no estate planning, nothing, we got a husband and wife. Husband passes first. That's because guys prefer it that way, folks, but they don't like dealing with the paperwork. But husband passes hypothetically first. Everything goes to wife. If we're both U.S. citizens, there's what's called an unlimited marital deduction. It means there's no tax at that moment. Okay, that's not where the problem is. The rub comes when the widow passes and we want to get it on to the kids. And if we didn't do any estate planning while the husband was still alive, we run the risk that what will then happen, barring a couple exceptions, but what really is typically going to happen is we have now the wife passing who had $6 million, and she's trying to get at the kids. Now, $6 million is roughly the number that we're going to sunset on, and if it doesn't change, that's why I'm using that number, and that's roughly adjusted for inflation. It'll obviously be a slightly different number when we get to 2025. We won't know that till we get there.
Sure.
But it'll be in that range. So if wife has $6 million and you guys do a great job on her investments, which you would, odds are that number is going to get a lot bigger. She may be at a point in life where she doesn't need to spend as much. You know, you aren't going out to dinner. You aren't taking the trips maybe like you used to. That may just continue to grow. And so if it hits 8 million or 9 million or 10 million and that number stays relatively static, there's a risk that down the road, her estate could still end up over whatever the exemption is going to be at that point in time, and they could change it as well. That's another possibility that has to be considered. So it's generally a good idea, especially if you're in a close call situation, to at least preserve part of the first spouse's right. So in the most extreme example, we got a $6 million estate. We could take half of that if it's all community property and put $3 million into a bypass trust as an example. And that is kind of like a Roth IRA in a roundabout way, because that trust money that's set aside for husbands, half of the estate, can be invested, can grow. It could, in theory, grow to $6 million or $20 million, and the estate taxes were already paid on it. So that can pass tax-free, whatever it grows to the kids. There are some other taxes to take into consideration because we don't get a step-up in basis on a B trust. So we have to weigh those things against one another. But sometimes there are assets that we plan won't be sold and will be retained, and we're more worried about that. So there's a lot of planning that goes into that, and that's really mostly done after the first spouse passes, the choice of the assets.
Right.
But you know, you have to have the infrastructure. You have to have that trust in place while the husband and wife are both alive to be able to have those as options. And I was just referring briefly there to what's called an AB trust, and there are various variations of that. There's ABCs, there's Q-tips, there's you know, we can have disclaimer style, we can have formula style. There's a lot of variations. So sometimes when people talk about, hey, I've got a great trust, perhaps the biggest question is, are you in the right trust?
That's so broad.
Right, because, you know, how do you know what you actually need?
Right.
Someone's got to guide you into explaining what these different choices are.
Well, wise words from a wise man. And we covered a lot today in a short amount of time. And we would love to have you back again to take a deeper dive on this.
Yeah, absolutely.
And so we appreciate you being here to give us the Estate 101 tour. And you're always a great trusted contact and resource for our clients. So we really appreciate that. And to our viewers, however and wherever you were watching, thanks for joining us in our digital barbershop. And we'll see you again next time.